got moved online. Everyone was gone because I was here anyway, and so I was like, I was getting some work done, and I went out to run to quickly get some food, and like there was like my car and someone else in the parking lot, which is perfect because it's usually really quiet, and I grabbed like a classroom because there's a controlled temperature because the library is always freezing. And people are walking in and out and stuff. So, got a final trial for family law. Family law practicum, that's Tuesday. Probably gonna go to Pikeville tomorrow. I'll work with Kyle on that. And just Virginia Civ Pro. I think we typically have an essay every Friday morning, but thankfully we don't have one tomorrow. So it hasn't been a real grind studying it, but just making sure that I'm having it.
I was over the super shop that I sent you today.
Okay.
Actually, with my dad at home, we're both there. I talked to Tom about it.
Nice.
So you'll be happy. He said he gets chocolate's good. School there. I'm not sure it's there. So he's got all his time that he goes to there. Okay. I'll let you know.
I love an excuse to go. It's the first one I'm really hoping. We did that last year for Kat's birthday. It's right in early May. It's actually a couple days after my last exam. It's like, oh, we can do that again. Could just save money and stay home.
Well, if it's a nice place that keeps up with your stuff, here in a couple of years, there's gonna be a casino there. So
Yeah.
Give you a reason to come back.
Yeah,
Spend the
absolutely.
weekend.
Absolutely.
Oh, I'm just gonna get some food.
They got really good stuff. It's worth the trip.
Yeah.
Yeah, I really like Bristol. I go down to like the Pinnacle. Just all the food that I can't get from me.
Taxes that like Tennessee just out. Virginia pay for half.
Really?
Because of Tennessee go 15 year moratorium business tax. Or they put it on Tennessee side.
Well, it's all Tennessee side.
Everybody knows it with the
Howdy.
Howdy.
the areas.
All right. Is there anybody online?
What's up?
How's it going?
Hey.
Well, Craig Tester over there.
Y'all hear me online? If anybody's there?
Doesn't look like you haven't plugged in online yet.
Oh, no, I see one
Just don't
participant.
worry about us, we ain't issue.
What's up, man? Yeah.
That's not mine. That is technically Austin's.
Is this what I want?
Yeah, man.
You got it. Then I was like,
I was just feeling bad for that.
Here's your $15 bonus. $15 bonus.
Oh.
I'll say the same thing I said to him, don't worry about me in love with me yesterday.
Yeah, five.
Yeah.
It's a great investment.
German chocolate and.
How are you, sir? I was like, yeah, I see you running around today.
No.
You guys ready?
Right, the Cowboys win the Super Bowl.
Ready for the Cowboys to win the Super Bowl? I'm glad that you're ready for that.
Oh, is that the food truck?
When you said food truck, you came to play day? How did you come today?
That's great.
I'll take some. Was there
Okay, because I'm not gonna help you.
It's a lot.
Oh, no, it's great. It's not.
I haven't.
So our cafe will open with the vendor certain.
Well, you guys.
In August, we don't have a vendor yet. So it's food trucks to, highly received.
What kind of vendor do you want?
Somebody that has good food, they can serve coffee and coffee stuff. Can I propose an idea? Yeah, and early dinners.
Oh, yeah. Some use Chrome, some use.
Like work study. I mean, I can give you the recipe.
I'll
Anything you want. You got 30 days to get it. Because on the 15th, I'm out. Don't sell your intellectual property, man.
Dude, I did not know that there were this
Hey,
many.
Jake, let me talk to Professor Russell first.
Sean was like, "Give me 20 donuts." I was like, "Well, yeah, give me one." Apparently, I'm this big.
Yeah, I know.
Like, talk with,
It's like donuts holes too.
we are looking to forward, Sean.
Hey, CJ, you want
We're
donuts?
actually trying to partner with Food City.
Yeah.
Proximity.
Oh, yes, sir.
Drop off. You can get a truck, right? So you can get it. This is y'all's part. Now, if we get somebody. Over the summer, now, the whole fireplace. Maybe 25 people here. It's part of the and then of course. Oh, yeah.
You can buy us all different with whatever part of it too.
Theoretically, so I'm glad I didn't tell you. He built in 2 months. Because I get a look at it. Ain't just. Most brands. I knew it wasn't be much of that. I'm still doubtful.
He will hurt you.
Food City is. Oh, I love that. I love it.
That's fair.
You got any contact? I mean, that's supposed to serve. We got it.
And we did.
Anyway, Starbucks. We were talking, I'm talking to Dylan, he was in. Get past this stage. We need to show you. It's not like there are a lot of Starbucks. These typical questions. Because I go down there. I didn't know who was there.
Get us over here.
They could have made it 5 minutes.
Yeah.
I had a lot of business.
And before they get to the good position, there is that creating an emotion is what it's called. Then you know what you go on that setting.
We had one of
So
those.
don't let them try.
Headquarters.
When I was in Israel.
I would literally just say
never. Not. Just real.
right, they do both.
A missive. Come in from Iraq. Because it's got a missile.
I'm not these guys. It's not one of the people who just do something because everybody else is doing it. Yeah, just like Ukraine. So I think the problem is 15 you can do something, you're just gonna write an email. Right. So. Should we do something? Yeah, something.
I know that, so I have my best friend, one of his best friends on sports, actually volunteered at and some of the other officers in the chat, they went over not to be in field medic, but to like help with supplies or pulling. Over the they got training package and such. And so like my husband.
That's all I got. I'll just say that.
That understanding, you know.
They know what it is. One more email, not gonna move that meeting. Something like that.
All right, so we'll go ahead. Can you all hear me online?
Yes, sir.
All right, thanks. Good. All right. Well, first of all, thank you all for coming out today to this event and welcoming Ms. Ware here to Appalachian School of Law. I know it was kind of a weird thing because we got that notice about COVID and I was really worried we weren't going to get people in here. Nobody was going to show up because he said everything's online. And
I'm sorry.
so I was feverishly talking with Dean Height and trying to get with Brian to make sure we moved from over there to over here in case we had to spread out a little bit more. So thanks for working with us and helping us. Ms. Ware here is with the Heritage Foundation. She's a fellow there. She's been published in many different places. If you go and just do a little Google search, she's got a lot of great writings on a lot of constitutional type issues. The birthright citizenship article was enlightening to me as well, because that's something I've always kind of been like, how are we parsing that, or what are people thinking about that? And what we wanted to do at FedSoc was, you know, we've had some fairly safe topics in the past, actually quite boring sometimes. You know, I think our last one was about COVID and small business law. So we thought we'd get a little bit more into a topic that would create some conversation on both sides. And that's the whole point of FedSoc. We bring in speakers, and the idea is that we have a conversation about the topics that we're bringing in, and be able to have both sides in a safe place, if I can say it that way, where we can debate those issues or learn about something we don't necessarily agree with or we do agree with. And so Ms. Ware she went to the University of Nebraska College of Law. She's also undergrad at University of Nebraska. She's the senior legal policy advisor.
So I'm actually now a full-fledged legal fellow.
She's a full-fledged legal fellow now with the Heritage Foundation, doing a lot of great work and on our Constitution. And so we asked Amy if she would come and speak about the Second Amendment, specifically as you may or may not know, there's a case going before the Supreme Court that should be decided any time now that she's going to touch a little bit on, as well as this push across the country to go, because we now have half of the country, you don't need a license to open or conceal carry. And so how is that case going to affect that? But I'll let her decide that and discuss that. So please welcome Ms. Amy Swear.
CJ, I can't tell, is it through this one or through that one?
It'll be through that one. You
Okay.
turn on. If it's on, then you're good.
That's a good question. I don't see it green light.
Now you're on. Now you're on.
Aha, there we go. That is why I can't have nice things. I don't know how to turn on microphones. Well, thank you, CJ. Thank you to Appalachian School of Law. Thank you to all of you both in person. And I see that we have a couple people online, which is great. Thank you so much for inviting me to talk about the Second Amendment. This is something that, I was just talking with some of you about. I came into this through the world of criminalization, not knowing that there was, such a role. It's like when people say I worked on the Hill. What does it mean when you say you work in public policy? Well, it means I get to sit around and I get to think through a lot of these issues and talk about these very important things, in a way that then. It enables me, one, to sit around and be a nerd all day, but then two, it enables me to stand up and talk about them and to have, as CJ said, some of these conversations that I think are very, very important. So today, we're going to be talking about the Second Amendment and the Supreme Court's current foray into the jurisprudence of public carry. So I'm delighted that you all have joined me today. I know you're coming up on finals. I see they have not even bribed you with food, which is amazing. There are I don't know how it works. So I'm delighted that you're taking the time out of your Thursday evening to join me. So today we're going to be looking at a topic that, while it's always important, I think has a unique relevance to this particular institution in this particular town. The right of the people not just to keep, but to bear arms. So it's not lost on me that just a couple months ago, Appalachian School of Law observed the 20th anniversary of a very tragic shooting that took the lives of, I believe, 3 individuals, seriously wounded 3 others. And if you're not familiar with that story, I'm sure many of you are, at the sound of gunshots, at least 2 students ran out to their cars, grabbed their own personal firearms, and ran back into the school. But by the time they had gotten here, by the time it took them to do that, the shooter had run out of ammo. It was essentially too late. There was nothing more they could do except to hold him at gunpoint. But fortunately, if he had had more ammo, they would have been the first responders. And as we'll talk about later tonight, this is not uncommon. Armed police officers, try as they might, are rarely on the immediate scene to stop violent crimes. Civilians are almost always their first line of defense when they are being victimized by violent offenders. And so the legal and policy questions sort of become this balancing act of, when and under what circumstances can the state tell ordinary peaceable citizens that they cannot be armed in a public place and must rely on the state's protection, given that the state is really there to actually protect them. But before we do that, I have a question. How many of you have taken a Second Amendment or firearms law class? How many of you have had at least one full class that has gone over in common law the Second Amendment? Okay, that's good. For those of you who haven't, that's okay. That's not unusual. It's unfortunate, but it's not unusual. So let's take actually a couple of minutes and catch everyone up to speed with the Supreme Court's current Second Amendment framework, because it's going to set an important foundation for what we're then going to talk about and for understanding what's happening in the space of public carry. This is a little bit like throwing you into the deep end, and just being like, yes, swim in public carry if we haven't gotten to where we are yet with the Second Amendment jurisprudence. So here's the 2-line didn't brief. Here's your SparkNotes version. SparkNotes still a thing? Until 2008, the Supreme Court had barely touched the Second Amendment. I would say barely touch it, but you will hear some people say that they haven't touched it at all. The first case that had any meaning at all whatsoever was 2008, District of Columbia versus Heller. It's not entirely true. There are several dozen cases that I think you could flesh, some importance out of. But there are three that, sort of set the stage for Heller and McDonald. So you've got United States v. Cruikshank in 1876. So that mostly dealt with the 14th Amendment and the prosecution of private individuals for infringing on civil rights. And so much of that holding has actually been overturned with respect to the 14th Amendment. But what's important is that the court still had some things to say about the right to keep and bear arms. Namely, keep in mind this is 1876, right on the heels of the 14th Amendment, that the right to keep and bear arms does not rely on the Second Amendment. It's not created by the Constitution. It's not created by the Second Amendment. It exists separately outside of it, and it is simply recognized as protected in that amendment. Then you get to United States v. Miller in 1939. So that dealt with the National Firearms Act. It was a regulatory scheme about taxing certain short-barreled shotguns and rifles and fully automatic firearms. And that, at its core, dealt with essentially what I think the court has come to term what are the types of weapons in common use, but dealt with the types of firearms that are protected in essence, and not with whether it was an individual right. And then importantly, I think a lot of people overlook Staples v. United States in 1994. So again, this dealt with it was a question of mens rea in a criminal law case. So this guy has his gun seized, and well, he said, well, look, I thought it was a semi-automatic firearm. That the ATF says, well, there are components of it that maybe make it a National Firearms Act fully automatic weapon. And what the court says there is basically everyone, including the dissent, acknowledges that semi-automatic rifles, as opposed to fully automatic rifles, which are covered by the National Firearms Act, are commonly owned and, quote, presumably not intended for unlawful use. That, I think, becomes important, not necessarily for public carry, but for some of the future iterations of what's going to come before the Supreme Court. So with all of that, I think it is fair to say that the first time the court really gets at the core of the Second Amendment, sets this sort of foundational precedent, is in District of Columbia v. Heller in 2008, and then in sort of companion case dealing with incorporation into the states. Just keep in mind, DC was essentially under federal law. So dealing with its incorporation into the states in McDonald v. City of Chicago in 2010. So in both of these cases, the court strikes down as unconstitutional what were at the time complete bans on the possession of operable handguns inside the home. So taken together, again, sort of the summary of these cases is that they affirm that the right to keep and bear arms is in fact an individual right. It's not centered on the militia. It's not limited to use within an organized militia. And that, importantly, it is fundamental to our scheme of order and liberty. It's applicable to the states through the 14th Amendment. They both involve this sort of history-centric approach. But both of these cases sort of acknowledge that their historical analyses are not exhaustive at all. And so the court uses these to answer some vitally important questions, these foundational Second Amendment questions, but it also indicates its own awareness that like, this is actually pretty limited. This is a pretty bare bones framework. It's not doing much more than saying, yes, there's an individual right. You cannot entirely ban operable handguns inside the home. And now here's a bunch of vague dicta. Please sort of keep that in mind, lower courts. And then, lower courts routinely have not kept that in mind. And the Supreme Court has just sort of kept a hands-off approach for the last, this has been 12 years since Donald, and really hasn't meaningfully, imagine if the Supreme Court went 12 years without taking up a First Amendment case or a Fourth Amendment case of any sort of significant meaning. So again, you get this sort of bare bones framework. It leaves many questions unanswered. Two of those, I guess three of those unanswered questions are going to be relevant to the case we're going to talk about to public carry, this New York State Rifle and Pistol Association v. Bruen. So the first important question that the court sort of leaves unanswered is this question of standards of scrutiny. What standard of scrutiny, if any, should apply to Second Amendment cases? So Heller and McDonald insisted only that, the interest balancing tests are bad. That's it. Interest balancing bad. Text, history, tradition, good. What is text, history, and tradition its own new standard of scrutiny? They don't really say that. They just keep referring to it. Or is text, history, and tradition something that needs to be incorporated into an existing standard? Like, is text, history, and tradition part of strict scrutiny or some intermediate scrutiny? They don't really say that. So what lower courts have done is sort of give this watered down intermediate scrutiny that, whether they like it or not, it turns into interest balancing. Borderline rational basis. The Ninth Circuit, under this test, has never found a single gun law unconstitutional, including, they've now said you have the right to open carry in public or to conceal carry in public, and somehow the right to carry in public is still not foreclosed. That is the point that the watered down has gotten to with this sort of vague standard that the court has left open. So the second question then is about that whole to bear arms part of the Second Amendment, right? So in Heller and McDonald, they say, yes, there's a right to keep arms in the home, centered on this right to self-defense inside the home. Part of the reasoning for that I'm quoting here is that the need for defense of self, family, and property is most acute inside the home. And so this suggests that the right should, in some capacity, extend to all places where the right to defend oneself is pretty acute. There's still no framework yet for analyzing the scope of that right outside the home. So can states restrict carry just to the home and allow it only for outside the home to those who need some sort of sufficient heightened need? Or is there even a right to bear arms in public whatsoever? And so related to this, finally, is this need for guidance on what the court referred to in Heller as this, what people have sort of now termed the sensitive places doctrine. So in Heller, and then I think they reference it again in McDonald, the court says, look, none of this is to cast a shadow of doubt onto long-standing and presumptively lawful restrictions on things like, and they reference bans on possessing firearms for felons, and then also on prohibiting carry in sensitive places like schools, courthouses, mental institutions, those hospitals, those sorts of things. And that's all that it says. So what does that mean? What is a sensitive place? If New York would have it, they'd be like the entirety of the public is a sensitive place. So where between the entirety of the public and nowhere constitutes a sensitive place? What does it mean to be presumptively lawful? If it's presumptively lawful, can that presumption be rebutted? If so, how? So that's sort of where we are with the court by the time we get to New York State Rifle and Pistol v. Bruen. Before we get into that, I think it's important to sort of set the stage. And CJ had referenced this earlier. What are the different state variations of frameworks for public carry permits? So there used to be 4, but as it now stands, there are no states that are explicitly what would be termed no issue. I'd say Hawaii is de facto no issue. They will admit as much, but the way that they have it is no, we have a way, we just don't grant it. So the first is actually permitless carry. Some people have referred to this as constitutional carry. I prefer permitless carry because I think it more adequately describes the process. It is permitless, there is no permit. If you are not otherwise a prohibited person and lawfully own a gun, you may possess and carry that gun in public, subject to other explicit restrictions they might have. Every state has some sort of thing saying, no, you can't carry a gun into a prison. Things of that nature, right? And this is actually now taken over the majority, I guess a plurality. Now 25 states are now permitless carry. It's about 1/3 of the population. It's getting closer, it's not quite a plurality of the population, but it is a plurality of the states. The second is what's known as a shall issue jurisdiction. It's just like it sounds. So there are different flavors of shall issue, ranging from everything from fill out the paperwork and send it in to my almost year-long process in the District of Columbia that cost me several hundreds of dollars to get my concealed carry permit in the District of Columbia. But generally speaking, what makes a shall issue jurisdiction is if you do whatever process they have laid out, they shall issue you that permit. They do not have the discretion to deny it. And then it brings us to the third subset, and this is the one that's going to be at issue in New York State Rifle and Pistol Association. It's what's known as may issue. So this is only at the moment about 8 or 9 states. It goes back and forth depending on how you want to characterize states like Delaware that are may issue, but generally speaking, they're less likely to deny the permit. But so may issue jurisdictions are characterized by usually 2 conditions. The first is, generally speaking, a requirement that you show some sort of good cause or proper cause. And that's typically required to be something above and beyond, well, if I'm in public, there may be criminals and I would like to defend myself. So generally it has to be more than just a general fear of crime above and beyond anybody else in your situation. And the second important aspect is that it almost always gives complete discretion to your local or state licensing official. So they have almost complete discretion to decide who does or does not meet that standard of showing good or proper cause. So New York is one of these latter jurisdictions. Now, there are some things you need to understand about New York's public carry law. The first is that New York, unlike most states, prohibits open carry of firearms. So unless you're in a hunting context, if you want to carry a firearm in public outside of the home and you want to defend yourself in public, you must get a concealed carry license and you must conceal carry a handgun. That is your only option if you want to do this legally. That's it, that's your option. Now, the second thing is that local licensing officials, again, have incredible discretion over what constitutes, in New York, they call it proper cause. And not only do they have that discretion, but the likelihood of your argument constituting proper cause depends almost entirely on which part of the state you are in and who your local licensing official is. The third thing is that gun permits and gun carry permits for New York City in particular are their own special nightmare. If you have a carry permit from your local county from upstate New York, it's valid everywhere else in New York State except for New York City. You need a special sticker from New York City and from their permitting office to carry in New York City. And let me put it this way, you are not going to convince New York City officials that you have good and proper cause. You're not. It's something like a 99 point something percent. It's a very high denial rate. And actually, to give you an idea of this, there's a very good Twitter thread from an individual who I believe now works for Gun Owners of America, who has gone through and like FOIA'd a bunch of these denial requests. And just the insane justifications that New York City has used to deny permit applications essentially come down to, have you tried being robbed more often? Have you tried being robbed more recently? Have you tried being robbed in this specific store instead of in your wife's store that is tangentially related to yours but is not actually the same store? Oh, we see that you were arrested and your case was cleared because it was a Fourth Amendment violation. Also, it wasn't cocaine. It was, it was milk powder. But you were arrested, so we don't think you have good and proper cause to meet the requirements. It really does come down to that. So in essence, in many parts of New York, specifically in New York City, there is no right, forget what the Second Amendment says about a right to keep and bear arms. There is no right of ordinary peaceable citizens to carry a firearm in public for self-defense. It is de facto a privilege for a special subset of people. LA County is like this too. In California, and in fact, when you look at both of them, overwhelmingly the people who do get permits are rich, white, and well-connected. And I'm sure it will shock you to learn that there are routinely bribery scandals involved in major jurisdictions like this. And that is routinely one of the ways in which people get their permits. And in fact, I think in both areas right now, there are federal indictments against former licensing officials currently ongoing. So let's talk about the facts of New York State Rifle and Pistol Association. You have 2 New York residents And I think at some point, I can't remember if they're still involved, there were some organizations involved, but at its core, you have 2 New York residents who have extensive experience in training with firearms. They applied for and were denied carry permits for their firearms because, and I'm quoting here from the city, they did not face any special or unique danger to their life. You tried being a victim of crime more often. They were willing to jump through any hoops. They're like, we don't care how much it costs. We don't care. We will take 3 days of training. We'll take 30 days of training. Just, you know, what is the process? They were willing to do any of that, but they're still denied. And so they sue, saying, of course, this is a violation of our Second Amendment right to bear arms in public. And New York defended this framework, essentially by arguing that its laws are perfectly reasonable regulations that are fully consistent with the text, history, and tradition of the Second Amendment. Now, there's more to go with that, but I think one of the best ways to sort of get at the core of some of these arguments is to go through what we saw in oral arguments. So if you haven't had a chance to read or listen to the oral arguments in this case, I highly recommend it. You know, I think, one, it's just, you know, sometimes with oral arguments, I think they sort of nitpick, you know, certain little tangential points that they go through. I think this really hits at some of the core issues that New York is facing, and that I think you will see come out in the opinion when we get to it. So the first is that New York's Solicitor General really appeared to concede a whole lot of points that seriously undermine their own arguments overall. So the big one is that New York City, so New York's argument was, hey, look, we do actually grant concealed carry permits or carry law-abiding citizens. We do this all the time. And then, you know, Justice Alito sort of presses her on this, and at the end, you know, she has to admit that, you know, that as a rule, if your argument is I'm a ordinary, peaceable New York resident who works late at night and has to wait for public transportation in a high crime area, that doesn't qualify you for a permit. As a rule, that will be denied. It sort of undermines your whole argument that, hey, no, you're an ordinary citizen can get a permit here. They really can't. Then you also just had some foundational aspects of the legal argument that I think that the state struggled to show are reasonable exercises of discretion. You know, you see this, I think, come out in some of the state tried to support its argument for why New York City had this, you know, incredible like 99% denial rate, but other parts of the state were a little bit, you know, more permissive to a point. So they tried to argue that basically these densely populated urban areas, well, they have more police officers, and so public carry is less necessary because you have more cops, and also it's dangerous because when you have people, and I'm quoting here, you have armed people packed shoulder to shoulder, that presents a higher public safety risk than when you have armed people in rural areas. You know it's bad when the Chief Justice starts poking at you a little bit on some of these issues. This is just one of, I think, the many examples. You had a couple really, really good one-liners in this argument, in this back and forth. What he says, he sort of highlights this paradox, right? In which the argument is, well, that residents of high crime urban areas are less justified in invoking their Second Amendment rights because, you know, there's a lot of police around in these high crime areas. And I'm quoting here, if the purpose of the Second Amendment is to allow people to protect themselves, then it's implicated when you're in a high crime area. It's not implicated when you're out in the woods. How many muggings take place in a forest? The answer statistically is very few, by the way. And so, you know, the Attorney General, your Solicitor General, you know, well, rapes and robberies happen, you know, like out on these deserted bike paths, but, you know, she sort of dodged, ducked, dives, and pivots away from that one. You know, I think when you look at the data, again, it's very clear that a person is far, far more likely to be victimized, and therefore more likely to want to invoke his or her Second Amendment right to self-defense in any given neighborhood in any of the 5 boroughs than in any square mile of rural upstate New York. That's just sort of the reality of high crime areas. And that's true despite the fact that New York City has one of the highest law enforcement to resident ratios in the nation. And at the same time, when you look at decades of data from the National Crime Victimization Survey, it shows that even just in general, most violent crimes happen outside of a person's personal home. So they either happen in a truly public space, or they are happening in a place that in New York, if you don't have a carry permit, you can't take it outside the home at all. You can't take it to a friend's house. Like, it's good for your home and the range. So it takes place somewhere in the city where you are going to need a carry permit. Finally, you saw New York sort of, and this is not unique to New York, but it was kind of fun to see them get called on this playing loose with, fast and loose with the history of the Second Amendment. So I think one of the glaring examples of this was Justice Alito chides New York for quite literally rewriting history in its brief. So New York had framed this early 19th century North Carolina legal manual as authorizing the arrest of, and I'm quoting, all such persons as in your sight shall ride or go armed. The state ended it there as though it was period. Problem is, it wasn't a period. What the text actually says is that such arrest should be carried out on all those who shall ride or go armed offensively. That's a very key omission when your argument is, well, no, there's this long line of legal history where states have prohibited public carry, period. So the word offensively at the time, and still it's more akin to modern brandishing statutes, like even in Virginia, you can't go around and just wave your gun around, in a way that's going to cause people terror and panic. And so finally, underlying all of these, and I think these are some substantial problems for New York, is a very real racial component to the history of a lot of these may issue and good cause laws. So regardless of what the intent of these laws may be, today, I think overwhelmingly, it's nearly impossible to look at the history of these laws in the United States and not come away going, oh wow, these were very clear runarounds to the 14th Amendment. Specifically, there were very clear attempts to render certain disfavored segments of society disarmed. And usually that segment of society is Black Americans. And they were generally upheld by courts who knew this, who understood this, and who sometimes did us the favor of saying the quiet part out loud. So I think, just one of the examples of this, it's a Florida Supreme Court case. It goes back to 1941. I'm blanking on the name, but more than happy to get it. It's a 1941 case that provides some of the insight into just how blatantly racist and that these discretionary permitting systems were at their core. So the court in that case overturned a white man's conviction for carrying a handgun in public without a permit in violation of state law. The majority ends up dismissing the charge or overturning the conviction on a different reason. It had to do with having it in his car, was that under the permitting statute or not. But you get in a concurring opinion, one of the justices just very nonchalantly explaining the racist origins and enforcement of this law. So he says the original act 1893 was passed when there was a great influx of Negro laborers in the state. The act was passed for the purpose of disarming the Negro laborers to give the white citizens in sparsely populated areas a better feeling of security. The statute was never intended to be applied to the white population, and in practice has never been so applied. Now, I don't know what the Supreme Court necessarily does with this today. I suspect if you see this come into play, it will come into play with the disparate impact of any may issue and good cause laws on those same populations today. We'll talk about that in a little bit. But I think certainly at the very least, it doesn't help that there is significant evidence that New York's current law, which is based on it's like 1912 Sullivan Act, is rooted in very undeniable racial animus against Italian and Central European immigrants into the city in the early 20th century. So where does this leave us? So looking at that, what should we expect from this opinion? It's a little part of me that was hoping it would drop this week, but it didn't. So here we are. Look, I think you get some people on the pro-gun side really excited, like, all permitting systems are gonna go, it's gonna be permitless carry everywhere. And on the flip side, you get the gun control advocates who will, it's like their worst nightmare. There will be nobody, it will be this wild west of no permitting. Look, that's not gonna happen. That's not at issue. You know, the shall issue permits are not at issue here. I think the court almost certainly keeps this, and rightfully so, to its very specific question of New York's very restrictive permitting process. But I think at the end, you know, again, you never want to play oracle with what the court will do. But I think judging by what we know of some of the justices, what they've said in the past, just how oral arguments went, you know, I think the way that this ends is generally the court says, yes, there is an individual right for ordinary peaceable citizens to carry firearms in public for self-defense, and states must in some way permit residents to exercise this right, subject only to, you know, some standard of reasonable regulations on time, place, and manner. And that leaves this sort of open-ended question of, you know, do they touch the sensitive places doctrine? You know, do they touch on what the standard of review is, or the, you know, do they deal with, is it text, history, and tradition, or strict scrutiny? The answer is I don't know, but it's going to be important because I think regardless, this opinion, irrespective of how broad or narrow it is, I think it's going to spell the death knell for frameworks in states like New York, California, Hawaii. Depending on how the opinion is written, and you may get a state like Delaware sneaking in there saying, does ours count? Let's find out. You know, so that's perhaps possible. But where the court goes from there, sort of what the next 10 to 20 years of carry jurisprudence looks like, I think is in a large part going to come down to how the court actually writes this opinion, which again is why I was hoping they'd write it so we could talk about it. But here we are. So those are just some of the things to be aware of. How does the court deal with that? How broadly or narrowly do they write it? Because some of the practical legal implications are going to depend on that, right? So I think depending on how broadly or narrowly they write this, I think it's going to indicate to states like New York whether or not they really feel like they need to make a good faith effort to comply with it, or at least with the spirit of that opinion. You know, I think what you will almost certainly see, you will see some states do what Washington, D.C. did in, I think it's 2016 or 17, when they had their no issue framework struck down. D.C. said, fine, please stop suing us. And they made a good faith effort. I mean, they didn't make it cheap or easy. Like I said, it took me from the time I said, I want a concealed carry permit to the time I actually got the permit, about 8 to 9 months. I had to take several half days off of work. And all in all, I think it was roughly $700 by the time it was done. You get to renew it every 2 years. It's fantastic. You know, so I think you will see some states just sort of throw up their hands and say, all right, fine, we'll do it in good faith. But I think you will also see some other states, depending on, again, you know, how seriously they think the court is going to take this and what some of that language is, especially with the sensitive places doctrine, say, we're going to see what we can get away with. And you're not just going to see, you know, financial and time barriers in terms of the process itself, but you will see the sensitive places doctrine come out to say, well, how many places can we deem as sensitive places where you can't carry? And you're seeing this already with some of the bills that have been issued or that have been proposed in New York, sort of anticipating what's going to happen. You know, some of these bills, it's like, okay, fine, we'll have a carry permit that you can get, but do you want to go to anywhere that sells food or liquid? Not even beer, liquid. Does it sell water? You know, in convenience stores, you know, gas stations, restaurants, grocery stores, anywhere that sells food or water. You know, do you have to rely on public transportation? Do you live within a half mile of a school, or a mental institution, or a government building, or a, you know, a insert building here? You know, I think you will start to see that sort of thing, to say, how can we disincentivize people? Say, well, what does it matter if I get a permit because I'm probably breaking the law if I walk out of my door? I think you'll start to see that sort of thing. And I think it's essentially, you will see the court still playing Second Amendment catch up, regardless of what it does here. I think part of that is, as you just said, a lot of states have moved beyond this. This is 8 or 9 states that we were talking about. Granted, you know, about 90 million Americans will be very pleased to have some method of carrying. But this is pretty limited. Most states at the time, you know, you're seeing this in DC and Illinois, for example, these more restrictive shall issue states that don't make it cheap or easy, that sort of set financial burdens and practical burdens. In DC, they say you have to take live range training. There is no public range in DC. You have to go down to Virginia or up to Maryland, and there's no way to get there with public transportation. You know, so essentially, like, are you poor? Good luck. You know, and I think most of the country has already sort of moved beyond these very restrictive frameworks into more subtly restrictive frameworks. And so you will see almost immediately the court having to play catch up with it, you know, even now. You know, I think it's likely that if the Supreme Court in this opinion doesn't do something with the standard of review, and I think even if it does, frankly, you are still going to have more than enough room to continue abusing the court's opinions, especially if they just give a text, history, and tradition standard. I mean, like, there is a reason that even New York and the United States in this case said, yeah, we're fine with text, history, and tradition. It's because they have a habit in the Ninth Circuit and in other not to be named circuits of, like, oh yes, we have found a case that maybe if we cut off, you know, the end of that sentence, that's basically similar to ours. The text, history, and tradition can be abused in that way. So I think you will continue to see this. Again, it sort of puts the court almost immediately back behind the 8 ball on all of this. And I think that's what you get for going 12 years without taking up some of these cases. So let's talk about, just very quickly, some of the practical criminal justice and public safety implications. I think that the big fear that you've seen from gun control advocates is that this will turn these states into this wild west of gun violence. Decades of data bear out the opposite. As well as just the basic logic of what we know about, 1, concealed carry permit holders, and 2, who is actually committing the vast majority of violent gun crimes in this nation. So put aside your thoughts on permitless carry and your arguments for and against permitless carry for a second. Because let me assure you, New York and Hawaii are not going to go to permitless carry. That is not going to be, oh no, we lost, let's say, fine, whatever, no permits. So they're going to go to some sort of shall issue framework. And so we have to look at it through that lens of, you know, is this going to be some Wild West? Between 1990 and 2000, you saw 16 states change their laws from either may issue or no issue to shall issue. During that time period, national rates for violent crime, homicide by gun, and other gun crime, including non-fatal firearm crimes, plummeted. They plummeted over that 10-year span. And then since 2000, and including in those states, by the way, since 2000, the trend toward more permissible public carry laws, as we said, we're now 25 states that are permitless carry. You know, there was a time when it was essentially New Hampshire. That was it. You know, so that has continued. And public interest in obtaining permits in these shall issue states has skyrocketed. You now have, so I think the last data that I saw on this was about 19 million Americans, adults, who possess a concealed carry permit. And keep in mind that as states have moved to permitless carry as well, that number was 3 million in 2000. Not a single state has said this was a bad idea. We need to go back. Not a single state has looked at the data in their own state and said, yeah, we should change that. And I think on the whole, what you've seen nationally during that time is that 90s decline it kept going at a generally slower rate, and then it sort of stayed stable at these low levels for about a decade. Now, we've had this fantastic crime spike in the last 2 years, but I don't think that can be reasonably put on the shoulders of any of these carry frameworks. So it turns out that ordinary law-abiding citizens absolutely can and have been now for 2+ decades trusted to bear arms in public, just like the plain text of the Constitution says, without turning this into some Wild West gunfight all the time. And I think that's consistent again with what we know about violent crime and concealed carry permit holders. Concealed carry permit holders as a class are some of the most law-abiding citizens in the country. They actually commit felonies at about 1/7 the rate of law enforcement officers as a class. And then when you combine that with the fact that they rarely use their firearms to commit crimes in a public place, in a circumstance in which it was furthered by their concealed carry permit, and when you can turn around and say, yeah, they would not otherwise have just broken the law with it, right? So a situation where it's like, let's say, they carry out to out to a night on the town with their friends, they get into an argument, they otherwise would not have a gun on them, they get into an argument, shoot someone out of spite. That sort of situation is actually incredibly rare. And then you flip it around and you say, well, what do we know about violent crimes? Statistically speaking, most violent crimes, and especially gun crimes, are committed by individuals who are already breaking the law 10 times over. They are already, one, unlawfully possessing their firearms, two, don't qualify for a concealed carry permit, so aren't going to seek one, and three, are already not dissuaded by the fact that they are violating several firearms laws in order to take that gun into public and use it criminally against someone. So then you sort of get this reality, to put it more succinctly, concealed carry permits generally only allow those who weren't otherwise going to commit crimes to defend themselves in public against people who are going to commit the crime no matter what. And finally, and I think this is important to talk about, just touch on quickly, but who are the people who stand to benefit most from this change to less restrictive permitting systems? And I think statistically, overwhelmingly, the answer to that is poor people of color who are disproportionately, one, victims of crime, and two, disproportionately arrested and charged with procedural weapons violations because they couldn't get carry permits. I do want to be able to take a good number of questions, and so if you're more interested in that, I would point you to, in New York State Rifle and Pistol Association, there is a fantastic brief by a coalition of Black public defenders and legal aid attorneys. I mean, where else, this was fantastic. Where else do you see Black legal aid attorneys siding with the NRA and sheriff associations? But it's an incredible brief where they go through, especially in New York, how hundreds of our clients every year are people who are otherwise peaceable, law-abiding citizens who the state said, you're not actually afraid. We don't think you have reason to be afraid. They're like, I have reason to be afraid. And so they're willing to own that gun, to possess that gun in public, because they truly felt afraid, regardless of what the state said. That is the only crime they will ever commit in their life. And now, according to New York, there are violent weapons offenders who will never get their firearms rights restored to them. And so it's a fantastic brief. I'd highly recommend that you read it. But I think that's sort of a good outlook of where we will go from there, and sort of what this will look like in the next couple of years. Though I think if we're being honest, I think the court gives the opinion that it gives, and then probably doesn't touch public carry for a good long time, unless you get some egregious law. It's like, do you have $20 million to give to the state to get your permit? That sort of thing. Because I think the next place the court goes is not to public carry, but to what types of weapons are protected. I think their next route is to take up an assault weapons case. I think that makes sense. It's like, all right, we've done inside the home, we've done outside the home, but what are the types of weapons? But with that, I would love to take some questions. I know we're a little bit over. I don't have a hard stop. I understand if you do, but I'm here until there are no questions. Yes, sir.
I just wanted to ask you a question about the careful data. So I've done some research over the last decade of what's transitioning, and homicide cases in general have increased by 4,000 in the last decade. So it was at 13,000, now we're at 17,000. About 45% of those homicide cases are involving handguns. The question is, when it comes to carry, open carry, majority of the time it's a handgun. It's not a rifle, it's not a rifle. So the question I have is because currently in the last decade, mass shootings have been a problem. And according to the empirical data set forth by the FBI, 61% of these mass shootings are involving handguns. So the question is, if we are going to want to move forward in the trajectory of allowing permitless carries, how are we going to help decline that number of homicides or put a decline in the percentage of mass shootings, because the majority of them transpire in the household of the individual and then carry on into the public?
So first, I'm not sure that I fully agree with you on this idea that over the last decades, they have necessarily increased. When you take the 2020 to current crime spike out of it, which I think there's ample evidence that is related to other factors. But let's say that it has. Let's say that the rate, not just the number, but the rate overall has slightly gone up. There's a couple things with this, right? So one is we have to look at what does the Constitution permit or not permit, right? If public carry is permissible under the Constitution, well, that takes it out of the policy question, right? And so you have to look first at the text, history, and tradition. But I understand what you're saying, right? So let's take that aside and let's say, what does this mean for homicide rates? There's 3 points I want to make here, right? So the first is something that I've already brought up, which is who is actually committing those crimes? Are they people who are going to be, say in New York, for example, or any of these states that are otherwise essentially no issue? Are they going to be people who are going out of their way to get their concealed carry permit? The answer is statistically no. So concealed carry permit holders, again, are overwhelmingly not the ones, not a factor in driving any of these homicides. And again, it's because of the reality of gun violence. So the only times that would matter would be a time where, again, you have a concealed carry permit holder who would not otherwise be motivated to break the law, who is carrying in a way they would not otherwise carry in public, who then commits that crime in that scenario. And again, that's incredibly rare. So I don't think you're going to see, in the sense of lawfully permitting these people who are not inclined and are not a large, significant part of the problem to carry, that's not going to be a motivating force behind any sort of homicide in public. With respect to whether it's, when you talk about mass shootings, which again are a very small part of the problem. We're talking, depending on how you're defining mass shooting, either a fraction of a percent to about 1 to 2%, the overall issue of gun deaths in the country. But I agree that it's important because of how people perceive it. Right? It's terrifying, it's devastating to communities, you can't get around that. Especially things like mass public shootings like the one we just saw in New York City, right? Where it sort of hits at your core of generally feeling safe in public. The flip side is not just how many people are now carrying guns in public who might become, mass shooters, right? I think again, when you're looking at mass shooters, they're generally already breaking the law to get there. I don't know of a single potential mass shooter who said there and said, I don't have a concealed carry permit. That's going to mess up my plan. You generally have people like the guy just a couple of years ago in Virginia Beach who knew that his city ordinance prevented him from taking a gun legally into the city county building where he worked and said, I don't care. You want to know who did care? Is one of the victims who died, who had been talking with her husband the day before and said, I'm really scared of this guy. He's freaking me out. Do I break this law and carry my gun into work? And she said, no, because I don't want to get fired. So again, it's a matter of who is actually dissuaded by those laws. And it's generally speaking, not mass shooters. Then on top of that, you have this reality of defensive gun uses in the United States. I'm going to throw out a number that is generally going to shock a lot of people who may not have heard of it. Almost every single study on the issue of defensive gun uses in the United States has found that Americans use their guns defensively between 500,000 to 3 million times a year. That's not me saying that. That is the CDC. Now, I will say there are a couple outlier studies that have found them to be about, depending on the one, between 60,000 to 100,000, which is still not an insignificant number of times a year. You also look at data from the FBI that looks at armed citizens, so non-law enforcement officer intervention into, they don't look at mass shootings, but they looked at active shooters. And it's still not an insignificant number. And I think actually they missed a number of, when you look at the ones that they did count, they actually missed a good number of mass shootings or potential mass shootings that were in fact thwarted by armed civilians, who again are generally speaking the first people on that site. So I don't think when you take all of that together, when you look at the public policy implications of this, you're going to see a way in which allowing, again, peaceful, ordinary citizens who are willing to go through the process of getting a permit. I'm not talking, we can have a discussion about permitless carry, but in the sense of taking New York and saying, you have to have a method, and you have to have some way of enabling someone to get a permit to protect themselves in public. I just don't see how, given that, we look at that and say, yeah, that's going to be a driving force behind it, that there's no rational connection between any of those things, and saying, yeah, well, that's the reason that public shooting or mass public shootings have increased, or that's the reason homicides have increased. I just don't see that data pointing to that reason. I saw a question up there.
Oh, my
Yeah.
question was actually, I just couldn't hear what you said. I didn't hear if you said defensively or offensively.
Defensive.
Gotcha.
Those are defensive gun uses. Yeah, it's again, I think that a lot of people look at that and they're like, well, how does that match up with when you look at verifiable gun uses, there's things you can find in a little paper, it seems to be a lot smaller, and it's because so many of these are actually not reported for various reasons. My internal lawyer goes, if I pull a gun on someone, I'm calling the police. A lot of people, especially if, for example, you live in a less gun-friendly state, might not do that because they're sitting there going, if I call the police and say I pulled a gun on someone, I might be the one getting arrested. And in fact, it's actually not, I won't say it's common that does happen, but it is not necessarily rare that happens, where that person is then arrested for, like what you said, you brandished a gun, did you not physically have your permit on you, those sorts of things. Or they just don't think, well, I didn't shoot anybody, so why would I call the cops? So it's sort of tangential, but to get back to that, I just don't see how anybody looks at that and reasonably says that is connected to any potential spike in crime. Yes, sir.
What is the talk about scrutiny analysis? I want to make sure that my terminology is correct. I've not read the Heller case in quite a while. So is it an individual right or a fundamental right?
So it's both, right? So in Heller, the question was, is it an individual right? Or is it some sort of militia-centric thing? But again, that because it was unique to the District of Columbia, so you had, I guess in McDonald, the city of Chicago, sitting there going, well, you never said that applied to us. You have not incorporated that to us. And so that's where you get that language in McDonald of the court saying, look, this is fundamental to our scheme of order liberty. It's incorporated through the 14th Amendment. It applies against the states. So it's a both and.
So if it's a fundamental right, is your prediction that it will be on the strict scrutiny or the stricter scrutiny end? For a fundamental right, it would seem to me that it would certainly move more in that realm than a rational basis. But if it winds up in intermediate scrutiny, we all know what that looks like.
Right.
It's generally not good.
Yeah, so yeah, to go back a little bit, because again, the court just sort of says rational basis bad. You would think if they're going to apply a tier scrutiny, right, that we've said it's a fundamental right, it should be strict scrutiny. And that's where you see a lot of people who put together hypothetical, and I tend to not disagree with this, to use the First Amendment framework as an example, where it's, if it's something that touches on the core of the right, we are talking, it's strict scrutiny. But when we're talking time, place, manner restrictions, maybe you see some sort of heightened intermediate scrutiny. But what has actually happened in the lower courts is they call it this two-tiered approach, this bifurcated approach, where the first question they ask is, they look at the law and say, does it touch on the core of the right? Is it protected under the core of the right? If the answer is no, then it's whatever, they're going to uphold it. If it's yes, then that's where they sit there and they go, oh, what standard of review do we use? What tier of scrutiny? Overwhelmingly, they haven't said strict scrutiny. Overwhelmingly, they have said, yeah, it's some sort of heightened, vague standard that somehow looks a lot like rational basis. You know, so I would tend to agree with you that if that is the route the court takes, and again, I have no idea what they do with this.
That could be a buttress against what I think you very eloquently explained is the insane future that we face if they're not clear. And
Right.
all of the permeations that come out of that, every state's gonna have these bizarre,
Right.
I mean, it becomes the
And-
wild, wild west
Right.
in that respect.
And that is sort of what you've seen. You saw this in some of the briefs, and I was actually surprised that the attorneys for New York State Riflemen's Association did not argue this. They said, yeah, we're fine with Texas history and tradition. I think a lot of people, including myself, thought that what they would do is say, no, we're fine with this sort of strict scrutiny, like two-question approach. And the way that you decide that first question of does it touch on the core of the right, is this covered by the amendment to begin with, is to work text, history, and tradition into that. And so because, like you said, that sort of gives it that buttress, that second thing, you to be like, you have to clear this hurdle, then this hurdle. But I would agree. I was a little bit surprised because that would have seemed to be the buttress. But I suspect that they were a little afraid of scaring off the court from addressing it.
I was gonna say, I think what you got is strict scrutiny, rational, intermediate, is you've seen a move in the court over the last 20 years that when the court wants to protect government action, they push a rational basis because it's easier to pass that test. When the court doesn't want the government to act, they push a strict standard.
Yeah.
And so what we've seen is, and I'm gonna put a label on it, label, conservative issues have moved toward being a rational basis issue, and liberal issues have moved toward being strict scrutiny. So they've attacked government action on both sides. And I also think that, I have not read Heller many times to do that. But one of the things I think Scalia said was he didn't really know what the rule was. He said, here's what I know. I know that a man who applied for a permit in DC, who was a skilled officer who had training, ought to have the right to have a loaded handgun on his bedstand. And he said, that's all I know. And he didn't go beyond that. And he didn't give it a standard. He didn't say strict scrutiny. He didn't say reasonable. He didn't say the doctrine you talked about, safe space or what. Sensitive. He didn't attach himself to that. He didn't attach himself to any of that. He just said that as American, you have this right. And I think what you said initially about there are rights that are probably there to carry a gun or outside of the Second Amendment, whatever it did, because at one point you said that the text is clear. Well, it took 250 years before we had our first case on it. So query of the text is clear.
So I think that there's two things. I want to touch on that one because I think there are reasons that the court waited so long. I think the first one is like prior to the 14th Amendment, this was not it was a much lesser issue because you didn't have this question of what were states doing. Your Second Amendment rights under your state were protected, again, by your state constitutions. So you don't really have this issue up until then. And then even then, you have Reconstruction with the court sort of like, do we really want to, sort of delve into this with the way that they're restricting it in the post-Reconstruction itself? And then on top of that, at the federal level, you don't really see the types of gun control that we think of as gun control today until you get into the 1960s and 70s at a federal level. And by that time, you sort of had the militia-centric approach entrenched.
Well, you also got two other things going. We didn't have handguns like this when we had our Constitution. Guns, handguns, small guns, they haven't existed for that long. And they haven't proliferated until the 60s. So we've got almost, certainly didn't have large mags, large numbers of bullets you can put in your hand. And so I think we're facing some issues that have driven gun control issues that just did not exist. And we've got a static or not static, depending on how you view it, constitution that just has a difficult time dealing with this issue. You know, when house in New York City for a long time, I didn't want anybody to have a gun. Because if you had a gun, that meant you were most likely about to use it for something bad. And it's that's just not personal. I just think it's very difficult to talk about this issue in absolutes. We don't have any rights that are absolute. What's told us that, and it makes me nervous. I think one of the things we've adopted in this country is because I can. And that is, I'm going to do something that bothers other people because I can. It bothers me great if I walk in and I know CJ very well. I know guns, you know, and talk about guns by lots of people. I can shot. But even if I walk into the grocery store and he's right beside me, if he's got a pistol on his side, it makes me nervous. I think it makes most people nervous. I think one of our problems is figuring out how to deal with people that really don't want to be walking around in the grocery store, but a lot of people carrying guns versus those that it doesn't bother. And we've got constitutional rights, but it's still a problem.
So I'm gonna address that real quickly. And I see you up there with your hand the whole time.
You're good, you're good.
No, like, this is sort of, you know, on the side an issue. You do have, I think, especially in the last 50 or 60 years, from a cultural standpoint, you know, the cultural divide has gotten infinitely greater. Where there's very few people sort of in the middle. You have people who are either very familiar with firearms or people who are very uncomfortable with them at a deep visceral level. You know, and it used to be the case, for example, we weren't talking about concealed carry. Some of these earlier concealed carry laws, it's because you could open carry. It was presumed that gentlemen open carry. It was the people you couldn't see with the guns that made you nervous, because presumably, why aren't you a gentleman who is showing you that you are armed? And so there is this sort of cultural respect, and the court had to address this a little bit. You know, I think that's an important part of its analysis is to say, look, you can't overlook the fact that some of these historical, you know, concealed carry permitting requirements had to do with it because you can open carry, which is why I think, you know, at the end of the day, they said, we don't care how you do it. There needs to be.
That's why they were so strict in many states. Couldn't hide your gun.
You know, so I think there is this cultural divide, and I think more importantly, that cultural divide lends itself to a greater inability for people to have these rational conversations, because it becomes an issue. You know, on the flip side, I can see CJ sitting there going, well, my constitutional right doesn't depend on whether or not it makes you uncomfortable, in the same way that, you know, my constitutional right to say, you know, X, Y, or Z opinion in public, even though it makes you uncomfortable or mad, that's irrelevant to whether I have that right. Now, I tend to agree that it is an issue. It is a cultural issue that I think lends itself more to the policy conversations than necessarily to sort of the legal conversations. And I will say quickly, you know, to talk about the clear text. What I meant by that is in that context, it says there is a right to keep and bear. You know, and I think New York and I think Hawaii's got a point where they would say you actually don't. Hawaii especially. You know, there is no concealed carry permit allowed. There is an open carry permit that you can get, but they have never granted it to someone who's not also a licensed security guard. So they would essentially say that we don't grant it to you peons out there. You know, get your security guard license. But I do appreciate that it is part of a larger conversation. And I don't know how we deal with that as a society going forward, except to say that's where, and I think the court will inevitably do this, is again, not to say, well, you must do X, Y, or Z, to say, well, at a very minimum, figure out how you're going to do your method and sort of led cultural. I mean, look, I lived in Nebraska for a while, lived in various parts of the South, where I've seen people, open carry in a Walmart. And to a large extent, it doesn't make me super uncomfortable. I'm like, that seems a little unnecessary personally, but that's just, but I get why people do it. Or you'll have people who, have their gun racks in the back of their trucks. It's not something that I would do because it's not something I grew up with. But I also understand that if, you tried to do that in other parts of the country, they'd have that reaction. And I think, again, that's where I think the court inevitably will leave open that ability for communities to, within reason, without foreclosing these rights, make those
Say
decisions.
we got an impossible, got an impossible job. I mean, my thought process, I think is pretty much what you said at the beginning. There's some kind of right out there to carry a gun that's outside the Constitution. Let's say, how do you, it can't be absolute, you can't be able to walk in. I mean,
When I say, look, I've sat on panels where I've been, the lone wolf saying, no, I actually don't think you have a God-given right to have a surface to air missile in your backyard bunker. I also don't think that falls under the bearable arms part of the Constitution. Or that, and at the end of the day, look, I think everybody, most people would generally say, for example, the Boston bombers do not have an unequivocal, unabridged constitutional right to keep and bear arms inside a prison, right? Or someone in a mental institution cannot have a shotgun under their bed. So I think to a certain extent, most people at the end of the day will get it. It's not unlimited. It just becomes a matter of what is the scope, what does it actually cover? And I think that's where you start getting into those conversations.
one more question.
Yep.
I try to read it as I can. There's at least some folks out there that write that the whole Second Amendment is gone on the rights.
Did you say gone or
Gone because it's related to militia. And when we signed the National Guard Act, all of the states gave up their rights to have militias. And so
I'm so glad this came up.
I'm serious, and I was like, I have not run into that.
So
And so when the states gave up their right to establish militias, and probably in there, so Virginia, North Carolina, South Carolina keep their militias so there wouldn't be a slavery revolt. How does that National Guard militia thing work?
it doesn't.
Okay.
So the first thing I do is point you to that theory is essentially reliant on what the court has now said was never a theory that was not the underlying premise of the Second Amendment. This idea of the in Heller, that was sort of the tension. Is it your right to keep and bear arms? Is it an individual right that exists outside of the militia, or is it tied inherently to the militia? And I think the court absolutely gets this right. They say, no, it's an individual right. They understood it as an individual right that the state could call upon you to exercise collectively because you had a duty to militia service, and that they would utilize that individual right and the fact that many Americans had their own individual arms, and they could call upon you to use it collectively. Now, if you're looking for a great article looking into how this wasn't just something the NRA made up in the 1960s, and how actually I say it's the opposite, it was always understood as that up until you got into about the 50s, 60s, 70s. There's an individual named David Kopel, K-O-P-E-L, a good friend of mine. He wrote a fantastic law review article for, I think it's BYU Law. It's titled The Second Amendment in the 19th Century. And he goes through like the first 150 years of American constitutional law. And it's basically a book, it's like 200 pages. But I think he very clearly, I won't say succinctly, this is 200 pages, but very pointedly goes through and makes that case of what this was always the concept. This is how they understood it. Now, in terms of where is the militia today, you have to answer the question, who are the militia? They sort of get into this in Heller and McDonald, this question, who are the militia? But I think the best way of understanding is that it's James Madison who said, it's the body of the people armed, that we are all the militia. And you actually see this today. So this idea, because I've heard this, right? It's, the militia acts, so it's now all under basically the state militias have been abolished. First of all, it's just not true. You look at every single state, with two unclear exceptions where they sort of imply the existence of an unorganized militia, has both an organized and an unorganized militia. So hello, gentlemen, over the age of federal law 17, you're members of the federal unorganized militia according to federal statute. And women, you're not off the hook. It depends on the state. Most states it's 16 or 17. I think Nebraska it's 19 because they're contrarian. If you are not otherwise a member of the state National Guard, you are a member of the state unorganized militia, including here in Virginia. So if you are a resident of Virginia, you can be called upon by your state into service. Now, some states sort of limit it, like you have to first call up the National Guard or your state guard. And if you're like, that's insufficient, then you can start, some states have very actually specific to this day, where they put it, and this is sort of the well-organized part, it's the well-organization of how do we actually call it up and call it into service, where it's, the practical measures of how we do that. Now, some states it's just sort of like, yeah, we have it. I think Virginia is one of them where it's like, oh, if we need to call up our unorganized state militia, I have just as much idea as Governor Youngkin does of how that's supposed to happen, because statutes don't say that. But in other states, it's very clear as to how that happens.
Virginia, I just read an opinion that was given to a city in Virginia, said you have absolutely no power under Virginia law to establish the militia for the city of.
And that is correct.
County.
That is correct, because the militia.
The citizens have the right to establish.
And that's what you actually see in, I'm blanking on the name of the case, but it's a roughly Civil War era case, but it was a similar thing in the court goes through this. It was some private militia that would go out and drill on their own, like in their own uniforms, and drill down the street. And the court says, like, yeah, you can actually ban those because the militia, not the individual right to keep their arms, but the calling up collectively into the militia, that is inherently a state function that the state gets to regulate. So actually that's not unusual for states to say, like, you can't have your own private militia. Now, where does a private militia start melding into like an armed community watch? That's not necessarily always clear, but that is inherently a state function. And so, this idea of like the militia has just gone away. Well, no, the militia as it was intended by the founders is always just a body of people armed. Now, the well-organized part, I would argue it should be a little bit more well-organized in terms of, how we actually know how to be called up. But no, it absolutely exists as it was intended. And to an extent, states, and this is not something new, a lot of these unorganized militia statutes actually came into effect around that same time. Around the time of the First World War. I think the latest one was
1903.
Yeah, 1903, but then you started seeing up through the First World War is when states started enacting their own, being like, oh, we should have either our state guard or our unorganized militia statutes sort of cleaned up. And the latest one to do it was South Carolina. It was either 2013, 2015. Like, oh, yeah, our unorganized militia statute, we should clean that up a little bit. So it absolutely exists. And I think it exists specifically within that context of states saying, well, we need to change this based on what federal law has done. Promise I get.
Before you get to them, real quick, the camera's gonna cut off in about 15 minutes. So I just want to see if anybody online has questions since we're here.
How do I tell?
Just ask them. They should be able to hear you.
I hear, I don't have anything, but just want to say thanks for coming, Amy. Much appreciated. It's been very informative.
Thank you guys for joining us online.
Does anybody online have any questions? The camera might shut off in about 15 minutes. Okay, sorry, no, whoever was it.
Yes.
It's been a while, so I'm trying to even think what it was. So.
Yeah, we took a huge tangent. Now we're talking about unorganized militia.
Yeah, we've gone over like different topics.
Sorry, let me know. You will be
Oh,
the
if I
first
think of it.
back to it, and then I saw you, sir.
Two questions, and feel free to answer them however you think.
The first is, where can the court look to discern a scrutiny standard? It seems like history and tradition isn't good for very much other than asking whether there is a fundamental right. You know, like, do we have a right to parent our own kids? It's not in the Constitution, but we can look at history and say, yes, it's there. But it doesn't really tell us like at what level the court should scrutinize the state. And then is there a good model out there? Are any of the circuits doing a good job thinking about it? And then my second question is, what's the social compact underneath the right to bear arms? You know, your right to speak is about, you know, the integrity of ideas flowing around the community, you know, the marketplace of ideas. It like makes democracy work. What's the compact between the individual and the community that's expressed in the right to bear arms?
So let's do I'll take them in order. So the first one, with respect to circuit courts that are doing it well, frankly, they've all sort of taken this two-tiered question approach that has just sort of become the standard under that. Generally speaking, it's the same standard that they've all essentially adopted, absent that, you know, the court stepping in. There are some that have done it less atrociously than others. To get the most atrocious, again, when you have the Ninth Circuit that has yet to find a single gun law that is, you know, that cannot be upheld under this standard, including incredibly restrictive ones to the point of writing the bear arms part out of the Constitution. You know, I think you get a sense of just how watered down that can get. So you know, it's then kind of hard to say, well, is there a circuit out there that's doing it correctly? Because I'm not sure that that's necessarily the best approach that they've taken. You know, again, I think, to me, what makes sense is mirroring it sort of off of that First Amendment. And it makes sense because the First Amendment, like the Second Amendment, the court has said this is a pre-existing right that exists outside of the Constitution. And you also sort of have this idea of like, what is the core of the right and where it's exercised versus restrictions on sort of time, place, and manner. And so to me, like that makes more sense, is to look to the First Amendment than to necessarily this two-tiered approach that lower courts have taken. But on the whole, and part of this is just the reality of what circuits get gun cases and why, right? So you're not seeing a whole lot of, you know, gun cases come out of Texas, for example. I mean, where are you seeing them come out of? You're seeing them come out of very specific circuits that are very, very specifically upholding those gun laws. So you haven't really seen a lot of other takes on it, just because that's where they keep popping up. I mean, you keep seeing California, DC, and New York and New Jersey get sued, and Maryland.
So they ask, does it touch on fundamental right?
Right.
As opposed to a mandate?
Yeah, so is this covered by the Second Amendment?
Then they apply, they say, yes, it touches on fundamental right, like how, like pretty much an absolute
Right.
right, like there's zero law, it's a fact of man. And, you know, then what test do they apply? Do you think that the court can avoid creating a test out of whole cloth like they did? Like Casey, they did the
Right.
undue burden, they just made it up.
Yeah.
But it has utility. Do you think the Second Amendment needs a test?
So the honest truth is I don't know, because I don't know how you word that in a way that, again, whether it's text, history, and tradition, you've seen some people suggest sort of, especially for carry restrictions, sort of, you know, like, does this impose an undue burden on the right, you know, for the balancing between, okay, yes, we will give you, it's shall issue, we will give you the permit, but we're going to make it really hard. Good luck if you're poor, can't take time off work, or have other responsibilities. You know, so you've seen some of that language sort of creep in some of the lower courts or into some of the conversations surrounding it. But again, what makes this so difficult is if you don't have the Supreme Court sort of specifically taking up cases to sort of shave down what that inherently must mean and what is so entirely out of bounds, and you just sort of have this bare bones framework, it makes it really easy, regardless of what the language is, for any lower court to take that, nah, it's not an undue burden. Or yeah, it is an undue burden. Or, you know, yes, that is part of the text history and tradition, and no, that's not, because they don't really have that guidance. And so I think more than anything, it's going to be the Supreme Court taking up and deciding those cases and meaningfully building out that framework, you know, in an objective way that is going to signal to lower courts what any of this means. I just don't know that the court is actually, it might in the future hopefully show a little bit more willingness to do it. I don't know that you're ever going to see it be like a First Amendment or Fourth Amendment issue where, you know, they're taking up 2 or 3 cases in, you know, every couple of years. Yes.
So kind of actually segue to it is, I take very little comfort in, ironically, and I aspire to be an optimist every day, but I'm gonna sound like a pessimist here. I take very little comfort.
Selective optimism.
Right. I take very little comfort in the ruling in McDonald versus Chicago, because essentially to exercise our right to Second Amendment, we have to play games with every state. If you go to Chicago right now, where the famous case comes from, and you apply for a permit, they put you through a rigorous, unending test that constructively removes your right to even have a gun. But that's how they square with the Supreme Court case. So with this New York case coming out, let's say it goes in favor of the gun nuts. So it goes in favor of them, right? Well, I don't take much comfort in that as a gun nut, because quite frankly, Ruth Bader Ginsburg set up a standard that is forever here. And it's that some of the rights in the Bill of Rights belong to the states, and they apply to the states, like the Fourth Amendment. You know, Ruth Bader Ginsburg loves to apply. Fourth Amendment is a fundamental right. It applies to the states in the Bill of Rights. But then in the same opinion, in the dissent, go, oh yeah, the Second Amendment, that doesn't apply to the states. That for some reason in the list of 10 amendments, it doesn't apply. Fourth does, but second. The Second Amendment isn't on a fair playing field. It's being constructively construed at the state level to essentially only exist if we allow it. So if you go to Chicago today and you want to get a gun permit, you have to submit to this constructive barrier. And how are we supposed to go forward with that if you're trying to give advice to people who want to press on and actually see constitutional carry flourish, see gun rights flourish in the country? It seems like it's a losing battle a lot of the time.
I actually, I never answered your second question, and I will turn back around to it. I just like completely forgot you asked the second one. But to address yours first, look, welcome to sort of the reality of, you know, how the 3 different branches of government and federalism work in practice, right? You know, this is, I think you see it very acutely in the Second Amendment space. I don't think it's unique to that. This sort of whole thing of, you know, what do you do if you just have a state that says, whatever, yeah, I know what the court said, whatever. You know, there's like the theoretical aspect of that, where it's like, oh, that shouldn't happen, and the reality where it does. And I think that the practical reality, I think the only real recourse short of like armed revolution, you know, like this sort of ultimate fail-safe thing, is to say you need to convince people, those around you, that this is bad or unconscionable or a constitutional violation, or that there is some practical value to having, you know, to lessening those restrictions. And sometimes it's not even related to guns. I mean, this is why we saw such strange bedfellows in the New York State Rifle and Pistol Association. You had the over-criminalization of the criminal justice reform people who suddenly got on board and said, yeah, when you do this restrictive permitting stuff, you are really, really disproportionately making life hard for certain segments of society. You know, to sort of look at its the effects that it has, and to convince people to get on board, to say we have to change this and make it work. And then also, you know, to get people into the space of saying, look, actually having concealed carry permit holders, you know, and not making this overly burdensome for them. This is actually a good thing, and here's why. You need to have that conversation from the inside. Like if you can't get it enforced from the theoretical means that should exist, that's how you have to do it. And it may seem, and in some cases, may actually be sort of a largely uphill battle. But if you would have told a lot of people 20 years ago that there would be 25 permitless carry states, they would have laughed at you.
I mean, you're right.
So it's not, on the one hand, it does seem this uphill battle, but it's not impossible. And it's, I wish I had some sort of here's this perfect framework for how that happens, and we can. I don't know that you ever get that
We're in
process.
a weird situation because culturally, we're talking about a divide, but I say it's more like a cultural, what would be the word? I actually can't think of a word that would be appropriate at the time, but it's essentially culturally, we're having a mental breakdown where if you look at what is designated as a school shooting or a mass shooting before Columbine, the best you can come up with was a dispute over a girl that two football players were fighting over a football game, and one person got shot, and that was a school shooting. So it was a school, and you could own a BAR, which is Browning automatic rifle, huge rounds, big old rounds in 1920. So
up to 1950, you could mail it yourself gun.
right. So when my grandfather was born, you could own a Tommy gun. The point is that this whole idea that guns providing this source of malice and malignant heart inherently existing and being in your possession does not reflect the record of US history. It is only recently, in the last 30 years or so, 35 years, that we've seen this cultural just dimension exist where suddenly all this violence is coming up in these methods where it's like people are insane. And that is concerning to me. I think we really need to look at mental health. Everyone's throwing it on guns.
Well,
It's not.
yes, we need to look at mental health, just generally. But so the way I actually want to answer this, I'm glad you phrase it that way, because this actually ties back into your second question that I just completely was like, oh yeah, it's like the first one. It's this idea of, what, I think the way you would phrase it was, what is sort of the underlying, not premise, but sort of like purpose of the Second Amendment that it rests on, right? So we look at the First Amendment and we say it's about this, the marketplace of ideas, right? Like that is the underlying good. It's how we balance that. I think part of, can you hear me? Did it?
I can't, no, you're good. You're good.
Oh, I will shout louder. I'll use my big voice. Okay. I think part of the way in which we help with that is to actually help people understand this. What is the underlying good that comes out of the Second Amendment? What is it premised on? Because I think people get caught up in this. Like on the one hand, you have some people who like to be like, it's all about armed revolution. Like French Revolution. Death to tyrants. 6 Semper Tyrannis, for every single slight and they don't get their way democratically. To people who are like, well, no, that really has nothing to do with it. Let's not talk about that. It's all about the individual self-defense. And I think when you go back and you look at this, and I will wrap this around to how this actually matters to sort of how do we not frame this in a way, but dealing sort of with that 30 years of losing track of this. So I don't think that's necessarily the first time in history this has happened, nor do I think that the framers were sitting there going like, oh yeah, no, like we never thought about what happens if people are just like, I don't really like guns anymore. What is the cornerline premise of the Second Amendment? I think when you look at how the framers understood it, how the founding generation understood that right, both in a natural right context, but also as they understood themselves to have as Englishmen at the time that they had inherited this right, it's premised on self-defense, but in general respect. So it's not just individual self-defense, and it's not just collective self-defense. It's sort of this all-encompassing idea of self-defense. And I think Joseph's story did a good job of breaking this down. And I wish I had the quote offhand, but I don't have it with me. But so he talks about this, right? And he's not the first one to call it the, what is the word that he uses? Basically like the cornerstone of liberty. And cornerstone isn't the word that he uses, but it's essentially what he means there. right? That it is sort of the shining star of liberty. And why is that? Its premise is on this idea of this natural inherent right of self-defense, right? So Blackstone calls the right to keep and bear arms not one of the fundamental rights, but he calls it an auxiliary right. That is one of these rights that exists within good democratic governments, good Republican small r governments, because if you don't have it, you don't have this buffer between what the government can do and its infringement on your natural fundamental rights. That is like, it acts as this buffer between you and the government and between you and the failure of government to protect you. So you have a natural underlying right of self-defense. We form good governments to better protect all of our rights, but we never give up that right of self-defense, either against the government when it infringes on our rights, either because the government can't be there to protect us in that way, we don't give it up to them when they're not there, and also because we have it against individuals in a state of nature. And so the way that Joseph Story frames this is, he's a very specific phrasing that he uses, where it's basically against the exploits of ambitious men, internal insurrection, and foreign invasion. And I think this really hits at, again, this, what is the good that we're getting out of it? It is the right of the people to be armed for the security of a free state. And the way that we see the security of a free state in practice being defended through what? Individual self-defense, through having, again, they feared these standing armies. But then all of history has shown that tyrants, the first thing they do is disarm the people and then use standing armies to oppress them. That's still, in fact, exactly what they do. I just completely lost my train of thought. Yeah, I know. So what happens?
What I'll tell you maybe is if you could address, I guess that other question is, because this is Grundy, and unless you want to
Okay.
nothing's going to be open.
Let me where it's about all of those aspects of that. Where I was getting to tie that back into you very quickly is, I think throughout time, space, and history, like we're in a unique place in history where like most of us are like, Canada's not going to invade us. Mexico's probably not going to invade us. We have Sea to Signing Sea. Yes, we may be mad about things, but like we don't think overnight the government is just going to like impose draconian law on us. Yeah, we all played Modern Warfare, 3, where the Russians invaded the US, but like, the Russians are going to invade the US, and the police will always be there. Because we sort of live in a society where it's like, with this unique place where like, we don't see that as a real threat, the way that, the founders, where they, the French and the British, and surrounded on all sides, or, the threat of foreign invasion during World War II, we just don't have that. But I think you start seeing, just how fragile some of this peace is, whether it's domestic tranquility. I think a lot of people for the first time in their lives, I used to have to like go back and be like, back before most of you were born, 1992, there were the LA riots, LAPD to sort of like let LA burn and Koreatown had to defend itself. I was like, no, we all sort of saw what happened during 2020 when the police can't be there to protect you on a wide scale. And they're like, I don't know if they're going to show up. I think you're seeing in Ukraine, like, oh, Russia might actually start like invading places, and this might become a problem. And so I think history, what is it? The history doesn't repeat, but it does rhyme. I think, and it's unfortunate because nobody wants that sense of domestic non-tranquility, but you start seeing it. And not to, I hate the phrase like take advantage of it, but like I think that's how you build people back into understanding this actually exists for a reason. You had the question, final question. Is it you with the question?
Oh, I did.
Oh.
It was kind of going back, I think, to one of like the last things that you said, about, I guess, the group of like public defenders is coupling with this, about being like in the best interest of people of color and low socioeconomic status. So I think it's important to reflect on the NRA like being one of the major gun groups and gun lobbies behind this permitless carry legislation, and their history of switching stances on gun control and gun violence, or gun control and gun ownership, and whether that's a right and who's actually should be afforded that right. I think that's important to consider when we're looking at this legislation. when 80% of citizens think that there should be some type of permit system, when the data shows that permits are states that have, like you mentioned, Hawaii has the lowest gun violence crimes in the United States. How do you think that a permitless carry, or state or legislation, as opposed to if the problem is the burden with the permit system, changing the burden, adjusting the system rather than getting rid of it completely? I interested to see, and maybe the Supreme Court will talk about it, how a permitless system would impact directly, like you said, people of color, lower socioeconomic status, specifically after like 2020, when we saw a lot of the unjust killings of specifically Black men who were legally law-abiding Second Amendment, exercising their Second Amendment. I just see definitely a clear danger of having a permitless system and that increasing or exacerbating like the issue or the mistrust between police and these like high crime or over police communities, rather than if the problem itself is with the permits adjusting the system.
So there's a lot to unpack there. The first thing I want to acknowledge is like, you are absolutely correct that there are organizations, including high profile ones, that I think that to their shame, and I'll even say specific individuals, you look at California's current public carry system, it was, to his everlasting shame, Ronald Reagan he signed that into law. I think it's just several weeks after the Black Panther open carried on the steps of the Capitol. And it was very clearly tied into that. This is not something that is new. You do have groups that have for whatever reason, declined to speak out on whether it's Philando Castile, and there are several others that have happened, unfortunately, just in this past year. And it is unfortunate, and I think it plays into what I think is a very harmful trope that the Second Amendment, and it's the amendment for middle-aged white men in rural America. No, you look at the 14th Amendment, and the court goes to this McDonald. The 14th Amendment, one of the major motivations behind that was explicitly that in the post-Civil War South, Southern states were looking around, we're not going to give the freedom any guns, and writing explicitly into their constitutions or into their laws that no Black people still can't own guns, so that they could be disarmed and essentially put them back into forced servitude in a lot of respects, and to continue to oppress them because they weren't armed. There is, in many respects, the Second Amendment, especially as it exists within the context of the 14th Amendment, it is the right of the oppressed. It is specifically the right of Black Americans, explicitly in that regard, the right of Black Americans. And I think it is very unfortunate. I think there's actually a longstanding history that has been overlooked and to some extent forgotten. I did not name this book, but there is a Black professor, Nicholas Johnson, who wrote a book. It's a fantastic book called Negroes and the Gun. And he goes through the history of Black gun ownership in America, and the ways in which that benefited communities, even those that were still significantly oppressed, but the ways in which Black Americans have been able to avail themselves of that right. And so I think it's unfortunate that it gets that rap because of the actions of certain, or the lack of actions of certain organizations. Now, very quickly, with respect to the last point you made about, what does this look like for minorities in high crime areas, who might now be armed? And I think in no other context would we look at something like this and say, yeah, police might abuse their privileges, so or police might abuse your constitutional rights, so that seems like a burden for you to think. No, we say that's a burden for the cops to figure out, and we hold them accountable when we don't. And I will say, from a practical perspective, I've heard this a couple times from in a number of states within the last couple of years that have gone permitless carry. They say, well, if it's permitless carry, cops are more likely to shoot you if you have a gun. It just doesn't make sense to me. The reality is, as a law enforcement officer, you don't know who has a gun. Regardless, when you pull someone over, unless they tell you they have a gun, you don't know they have a gun. So this idea of, well, if you have a permit, then you have a gun, they don't have, like smart Google glasses going, this person has a permit, this person doesn't. Even if they did, the people that they're overwhelmingly going to be worried about are the people without the permit who have the gun, who don't tell them they have the gun because they want to do them harm.
Police are worried about whoever has a gun in their hand. They are trained to suppress that gun the minute they walk in the door.
Right.
So whether you have a permit or don't have a permit, or you're
So
a
now-
good citizen like CJ.
So now we're talking about,
People, let's finish. They're gonna point their gun at CJ. If he can't explain himself appropriately, if he lifts his gun up, he's gonna get shot. And if his skin was a little darker, he's probably not even gonna get a chance to explain himself. So the thought that police are 100% behind this kind of thing is just false. There are many, many respected police officers who do not want anybody carrying their history.
well, and that's what it is. It's not that they care about permits or not. They would just prefer that fewer people carry because it makes their job
Right.
easier. Now, again, I think when we're talking about constitutional rights, the onus is on law enforcement to figure out how to deal with that. And it's also on law-abiding citizens to figure out how not to be idiot with your gun regardless of skin color. But I'll give you one example before we leave about how very serious of a problem this is. And I acknowledge that this is a problem. So I wasn't one of the first, there's like the first wave of people who got a DC carry permit, like before it was cool during the pandemic. And the district had just changed that law, and a lot of cops didn't even know it at the time. So when I was taking training, what they would tell you is, if you get pulled over, you have to tell them you have a gun, expect to be detained for several hours while they figure out, oh, wait, no, actually, you do have a permit, you can do this. Just expect that it's not going to go well. So about a year later, I got pulled over for like an expired something on my car. DC police, Capitol Police pulled me over. I said, I'm required by district law to tell you that I'm a concealed carry permit holder and a concealed carry permit issued to me with the District of Columbia, blah, 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 it's my whatever, expecting, me to get pulled out of the car. Keep in mind, I'm dressed like this. Something similar to this. The young white woman in Capitol Hill. The cop's response, and in my mind, I'm like, I'm not going to work today. I don't have to call my boss to be like, I got arrested. It's, I'm going to be released. Don't worry about it. No, the cop's response was, oh, hey, that's cool. Can I take a picture of it to show like my training, my trainees? Because I haven't seen one of these before. You know what I mean? He sort of, took it out. I still thought he was a little like dramatic with it. But I know a number of other people who, if they didn't quite look like me, it might have been a little bit more dramatic. It might have ended up more, or at least been more likely to end up like filing no Castile. Because I've what the cops said, just go back to your point was, yeah, it used to be the case that if someone had a gun and they weren't a cop, they were going to jail, and it was just really easy for us. It's unfortunately not how constitutional rights work. The easiest solution for cops is not necessarily the best constitutional solution. So I fully
That's
acknowledge.
not the constitutional solution, not necessarily the best for society.
Right. But that said, I think, to go back to, he has now left, but this is the last point, I promise. This idea of what is the balance between the right that you have and then sort of the responsibility that you have to society. And I'd say, at least from a personal perspective, I, as a concealed carry permit holder, I, as a gun owner, I have a responsibility, at a very baseline, to not be an idiot with my gun. I also have a responsibility to take things into account, like how might a law enforcement officer perceive me? They have a responsibility to learn how to adjust to the reality that more people are carrying. But I also have a responsibility to recognize that anytime I pull that gun out, especially in a chaotic situation, tragedies might happen. And it is an accounting that I need to make within my own mind. What I mean by that is I think it was within the last year, in Aurora, Colorado, there was a concealed carry permit holder who stopped a mass shooting, probably saved the lives of dozens of cops. An individual had come into the city and just started targeting law enforcement officers with an AR-15. The permit holder draws his gun, he shoots the mass shooter, stops the mass shooting, and I don't say this to blame him, but he did something that I would not suggest doing, which is he disarms he takes the rifle of the guy who he had just shot, My guess is he was going to, render it inoperable and disarm it. Other law enforcement officers roll up. And again, you are correct. In their mind, they're going, there's a guy out there shooting cops. We're looking for the guy with the gun. And they roll up and they see an individual with an AR-15 and they see dead cops and they shoot the concealed carry permit holder. And I think that is something that, as anyone who wants to carry in public, this is one of the things you need to take into account for yourself as part of the factoring that goes into, do I draw, do I not? Just like if I'm on a crowded bus, do I draw, do I not? If there's other people in my line and I'm in a chaotic situation, do I draw, do I not? Which is why I'd say even in a permitless carry jurisdiction, we should be encouraging individuals to take that training from within the gun community, to take that factoring into account so they're not having to think through it in the chaos, but that it's a factoring that they've already considered so that they're making smarter decisions. Because I think you're right. There is a duty sort of on both sides to sort of adjust to that reality.
I'm gonna cut you off.
Yep.
No, really appreciate you coming out here. Appreciate you all for being here. This is a great discussion. I kind of made a few notes. Austin talked about being a gun nut. I don't think anyone's more of a gun nut than I am.
Yeah, it's true. You got me beat.
When I started living in Perry, Texas in 2003, there were 4 unlicensed carry states. 4. In 9 years, it's increased 600%. And there are 4 other states right now seriously considering it, most likely to pass. So we're probably going to be at 29. And I think if such laws were an issue, we know by now, and there'd be a reverse trend as opposed to a trend towards this. But again, that's a great debate to have because there are concerns. As a leader of a gun rights organization, I understand that one, we have to be responsible. I don't want just any old nut job, crazy psycho carrying a gun that's going to hurt people. So there's always a balancing test, and we always, of course, encourage training, even if it's not required. Go and get training. And historically, what we've seen with these unlicensed states is as the state has removed the need for a permit, instead of less training, these gun owners are getting more because now instead of spending up to $700 on a license, they're taking that same money and going and getting real training. Because let's be honest, if anybody who here has a license to carry, either concealed or open. I don't know about y'all.
Government?
What's that? Because in Texas, you sit in a class that's absolutely useless. You don't learn how to shoot a gun. You don't learn in these classes how to be a good shot, how to take care of, you learn what the law is. That's pretty much it. So even the permitting process isn't making you safer, it's making you more knowledgeable. But we always, whether you're a gun nut like me or somebody that's just concerned and more in favor of gun control, the impetus is that we all push together to make sure that training is an essential part of this. And so if y'all want to go with us, we're going to go over to El Sombrero and have some dinner if you haven't eaten yet. But I really appreciate again y'all coming out here. Amy drove a long way. Thank you. I'll see you over there. I just wanted to make sure they were still open.
That's fair enough. I will say this was such a finals, and I know it's a Thursday evening. But I appreciate everyone staying for questions. And this is the first time I think I've had so many people go, no, questions. I appreciate it.
Take care, online people.
Tell me
here.
down here if anyone wants to see.
Thanks again, y'all.
CJ,